Now, my topic is very large. It obviously has historical, legal, economic, and cultural dimensions. Please permit me to concentrate on the constitutional dimension only for today, and perhaps a fuller discussion will have to wait for some other time. Let me now go to slide number 2. As we approach the slide number 2, please, next one. Yes, as we approach the 58th anniversary of Malaysia, we take note with concern a large reservoir of discontent in our sister states across the South China Sea. We all need to put our heads and hearts together to diffuse the tensions and to find just and lasting solutions. Having said that there is a problem, let me, however, also point out that these problems are not unusual. Such tensions are inherent in all of the 30 or so federal systems in the world. In Malaysia, we saw federal state discord as early as 1966, when Sarawak Chief Minister Stephen Kalong Ningkan was deposed after a federal declaration of emergency. Next slide, please. Next slide, number 3. In subsequent years, many other areas of discord went unnoticed because of the overwhelming power of the alliance and the Barisan National Government. But since the general election of 2008, 2013 and 2018, when Barisan National lost its 2/3 majority in 2008 and 2013 and lost the election in 2018, politics has become more competitive and democracy and free speech are finding greater expression. Consequently, we are witnessing the open airing of grievances. Now, this is not entirely a bad development. It shows an emerging democracy. Let me say this to you in a light-hearted way. If in any relationship there are no problems, the absence of the problem is the problem. If there are no grievances that are aired, that means that one side has been able to silence the other. So personally speaking, the witnessing of open grievances shows an nascent emerging democracy in Malaysia. Next slide. In plural societies around the world, it is not uncommon to allow ethnic or other groups that claim a distinct identity to exercise autonomy over affairs of special concern to them. We have to accept this fact that most societies in the world today are diverse, multi-religious, multiracial, multilingual, multicultural. So we have to find arrangements whereby unity need not mean uniformity. That unity must be a unity in diversity. Kashmir in India till August 2019, Quebec and Nunavut in Canada, regions in Switzerland, Spain, Russia, Philippines, Thailand, Indonesia enjoy some such asymmetrical arrangement. In other words, the various regions are not necessarily equal to each other. Some have more rights than the other. Next slide, please. What's the special position of Sabah and Sarawak under the Federal Constitution of 1963? When Sabah, Sarawak and Singapore joined hands with Malaya to reconstitute the Federation of Malaya into the much larger and newer diverse Federation of Malaysia, the significantly amended Federal Constitution granted them a number of ironclad guarantees of their autonomy and special position. I fully acknowledge that between the law in the book and the law in action, a wide gap has developed. But nevertheless, let's take note of the legal provisions. Next slide, please. Though the existing constitution of the Federation of Malaya was retained, the Yang di-Pertunagon remained the head of state. Islam remained the religion of the Federation. At the same time, 89 out of 181 articles and 12 out of the 13 schedules of the Federal Constitution were amended. 37 new articles were inserted into the Federal Constitution. So quite at so many places you'll see Article 161A, B, C, D, E. These are all additions later on. 11 articles were totally removed. The nation was given a new name. Next slide. Now, there was plenty justification, of course, for this special position. First of all, the 1963 Pact or Agreement between the Federation of Malaya, the United Kingdom, North Borneo, that is Sabah, Sarawak, and Singapore, was drawn up after a lengthy process of bargaining and negotiations. The delegates of Sabah and Sarawak made it very clear to the Intergovernmental Committee, IGC, which was headed by Lord Lansdowne, and the deputy head was Tun Abdul Razak, that special treatment was a precondition for constituting Malaysia. Sabah summarized its demands in its famous 20 points memorandum. Sarawak expressed them in similar 18 points. Next slide. Though the IGC report, Intergovernmental Committee report of 63 and the Malaysia Agreement of 1963 were not fully incorporated into the Malaysia Act 1963 and the Federal Constitution, their sanctity and quasi-semi-constitutional status have been reiterated by our courts in several cases. I won't go into all these cases, but I think there is a scintillating dissenting judgment of the then Chief Justice of Sabah and Sarawak on a matter whereby Tan Sri David Wong Dakwa in T.R. Sanda felt that the terms of the IGC report should be regarded as part of the constitutional setup of Malaysia. May I also point out to you that this is not uncommon. In the UK, the Bill of Rights, it's not an act of rights, it's a Bill of Rights. It never got passed by the three institutions of Parliament. The Magna Carta and many other such constitutional documents are regarded as part of the heart and soul of the constitutional setup. Next slide, please. Around the world, historical, pre-constitutional and foundational documents are employed to interpret the Constitution, and we have a number of local cases which affirm this point. Now, Sabah Sarawak's cultural and religious distinctiveness from Peninsular Malaya justifies special treatment. Sabah and Sarawak contribute huge territories. Approximately 60% of Malaysia consists of just two states, that is of Sabah Sarawak. Their combined areas 198,000 square kilometers, exceeding Peninsular Malaysia's 131,000 square kilometers. The coastline of Sabah Sarawak is 2,607 kilometers compared to the Peninsula's 2,068. Next slide. And of course, Sabah Sarawak are a major source of petroleum, natural gas, and timber, and they basically supply a very large percentage of funds for the national exchequer. Despite their potential wealth, there are severe problems of poverty and underdevelopment in these states. Such necessities of life as piped water, which in Peninsular Malaysia we take for granted, roads, social and health facilities, and internet are not on par with West Malaysia. And then, of course, international basis, the 1963 Malaysia Agreement was not a mere domestic agreement, but an international treaty giving international law basis to the guarantees for Sabah and Sarawak. Next slide. For the above reason, Sabah and Sarawak were conferred special powers not allocated to the Malayan states. Actually, the topic is very large. I've only emphasized about 15 or so areas where special rights have been given. Next slide. The first area is legislative matters, lawmaking power. Schedule 9 contains a supplementary state list. There is, of course, a state list for all the states, but there's a special supplementary state list for Sabah Sarawak. The lawmaking powers of Sabah Sarawak are broader in 6 matters, including native law and custom, incorporation of state authorities, ports and harbors, land surveys, the Sabah Railway in Sabah, and water supplies and services. Next slide. There is a supplementary concurrent list in Schedule 9. This special list extends the legislative competence of Sabah Sarawak to cover 9 matters, including personal law, adulteration of food, shipping under 15 tons, water production supply, forestry research, charities, theaters, medicine and health. Next slide. Next slide, please. Thank you. Article 76A and 95C, Clause 1. Under these articles, the Yang di-Pertuan by order has conferred on Sabah Sarawak special powers to legislate on the federal matter of carriage of goods by land. And that's the Borneo States Legislative Powers Order 1963. Next slide. Federal power to have uniform laws are not applicable to Sabah Sarawak in some areas. Under Article 76, Clause 1B of the Federal Constitution, though there is a federal state division of lawmaking power, Parliament may legislate on state matters for promoting uniformity of laws of 2 or more states. But this power of the federal parliament is not applicable to Sabah and Sarawak in some areas, which are land, agriculture, forestry, and local government, which are exclusive to Sabah and Sarawak. So the National Land Code does not apply in Sabah Sarawak, which have their own land law. Next slide. Amending the Constitution, that's my second issue. The power of amending the Constitution, which belongs to the federal parliament, is not as extensive in relation to Sabah and Sarawak as it is in relation to the West Malaysian states. I have to point this out to you, that in relation to the West Malaysian states, Parliament has no need to consult or obtain the consent of the West Malaysian states in amending the Constitution, except in one area. One area is if you were to take away the territories of a state, then under Article 2 brackets B, you have to get the consent of the legislature of that state. In all other areas, the states of the Federation in West Malaya need not be consulted. But under Article 161E, Clause 2, the consent of the governors of Sabah and Sarawak is required to a constitutional amendment affecting the special position of Sabah Sarawak on matters of citizenship, judiciary, federal-state relationships, religion, language, native rights, quota of MPs in Parliament. Robert Lingi versus Government of Malaysia, Fong Fong Chen are the famous cases on these points. So amending the Constitution that would affect Sabah Sarawak would require the consent of the governor. I'm sorry to report to you that it's the consent of governors, not the consent of the Sabah and Sarawak state assemblies. Next slide. Regrettably, some constitutional amendments have diluted the special position of Sabah and Sarawak. An example is amendment in 1976 to amend Article 1, Clause 2. I think all of you know about this. Previously, the Perlembagaan stated that the states of the Federation shall be A, the 11 states of Malaya, B, the 2 Borneo states, and C, Singapore. Sabah and Sarawak were mentioned separately to underline their special status. But now Sabah and Sarawak are included in Article 1, Clause 2 as 2 of the 13 states. So this was definitely a status downgrade without their consent. If consent was obtained, then perhaps the amendment is legal, but to the best of my knowledge, there was no consent to this amendment to Article 1, Clause 2. Next slide. Federalization of critical state matters such as water and tourism has taken place. Labuan has been federalized. Sabah Sarawak argue that the Territorial Sea Act 2012 reduces their territorial waters from 12 to 3 nautical miles in violation of Article 2B. Article 2B is the territories of a state. So if you reduce the territorial waters, indirectly you are reducing the territories of the state. The power of the governors to appoint judicial commissioners to the High Court of Borneo was handed over by constitutional amendment to the Yang di Pertuan Agong. And sadly, the challenge in the federal court failed. At the Court of Appeal, Justice Tan Sri Wong gave a beautiful judgment saying this is a violation of the rights of Sabah Sarawak. But the federal court overruled the Court of Appeal. Next slide. Article 121 was amended to emasculate the powers of the High Court, the Court of Appeal, and the Federal Court, and that would include the High Court of Borneo, and no consent was obtained of the governors of Sabah Sarawak. Likewise, Article 121 Clause 1A was inserted. 121 Clause 1A says that the High Court has no power over matters of Islamic law in the jurisdiction of the Sharia courts. Now, was the consent of the governors of Sabah Sarawak obtained in cutting down on the powers of the High Court of Borneo? Labuan was federalized, and there again, there is a question whether this was done in accordance with Article 2B and 161E. 2B would be the consent of the Sabah Assembly. 161E would be the consent of the governor of Sabah in the federalization of Labuan. Next slide. Now, position of Islam in Sabah and Sarawak. This is very controversial. Let's approach it in a theoretical, intellectual way. In 1963, there was no official religion in Sabah or Sarawak. Sabah later amended its state constitution to insert a state religion, Islam. In Sarawak, there is no state religion, though the Yang di Pertuan Agong is recognized as the head of Islam in the state. In 1963, the federal constitution contained Article 161C, which provided that if financial support is given to the federal government, is given by the federal government for the Islamic institutions and Islamic education in the Borneo states, the consent of the state governor must be obtained. Further, an equivalent amount will be allocated for social welfare in Sabah Sarawak. Article 161C was repealed in 1976. Next slide. In 1963, there was also an Article 161D, which was repealed. 161D was an exception to Article 11, Clause 4. 11, Clause 4 says that any preaching of religion to Muslims can be regulated or banned. In the context of Sabah Sarawak, this provision was not meant to apply unless by a 2/3 majority of the State Assembly. Sadly, 161D was repealed in 1976. Next slide. The native character of Sabah and Sarawak has been diluted over the years, and Islamization has been a key policy of the federal government since the 80s. Next slide. In recent years, the moves towards an Islamic state. In 2001, the then Prime Minister, declared Malaysia to be a Sebuah Negara Islam. The plan to introduce hudud laws a few years ago, Rang Undang-Undang 355, the attempt to export the peninsula's hardline Islamic trend, the restriction now lifted of import of Bibles in Malay, and the federal court decision in titular Roman Catholic Archbishop of KL, whereby the word Allah cannot be used in Christian publications. Now, these clearly arouse discomfort in Sabah and Sarawak. State Sharia laws have been enacted to provide that in the case of native Muslims of Sabah Sarawak, native law will not apply, and the Sharia courts shall have jurisdiction. This has led to conflicts between Sharia and native courts. I personally know of these conflicts, but this is not a matter publicized very well. Especially these conflicts exist in those cases where the parties prefer to be tried under native law in native courts rather than be tried under the Islamic state law. Next slide. The court system. In Sabah Sarawak, native law is widely used and partly codified. We have an admirable recognition of legal pluralism. There is a developed multi-tier system of native courts. However, sadly, native judges need better training, professionalism, and independence. This is something Sabah and Sarawak have to address. Federal government cannot address this. It is noteworthy that unlike Sharia courts under Article 121 brackets 1A, native courts are not independent of the High Court. May I explain this point? Former Chief Justice Tan Sri Richard Malanjan had made this point on several occasions. When it comes to the Sharia courts, they have been given immunity from the High Court. But native courts have not been given such independence of the High Court. Then there is a High Court for Sabah Sarawak, and the requirement is that the appointment of the Chief Judge of Sabah and Sarawak by the Yang di-Pertuan Agong on the advice of the PM and the Judicial Appointments Commission requires the consultation with Chief Ministers of these states. Article 122B, Clause 3. Next slide. Appointment of JCs, Judicial Commissioners. Prior to 1994, it was the law that Judicial Commissioners in the High Court for Sabah Sarawak shall be appointed by the Yang di-Pertuan Negeri on the advice of the CJ of Sabah Sarawak. However, Article 122AB was amended in 1994 to transfer this power to the Yang di-Pertuan Agong on the advice of the Prime Minister after consulting the Chief Justice. So previously, actually, it was the Yang di-Pertuan Negeri. Now it's the Yang di-Pertuan Agong. And this amendment should have required, this constitutional amendment should have required the consent of the governors of Sabah Sarawak. There was an argument that this consent was not obtained. Next slide. Empanelment of Federal Court. The Intergovernmental Committee recommendation, para 26, chapter 3, that when an appeal involves the rights of Sabah and Sarawak, the Federal Court panel must have at least one judge from Sabah Sarawak with Borneo judicial experience, has not always been honored. So here is a extra constitutional, pre-constitutional issue or pre-constitutional principle which has not been respected all the time. Most of the time it has not been respected, and there are cases where this principle was raised and rejected. Native cases involving land, livelihood, and custom. These cases are often heard by peninsular judges with no Borneo experience or appreciation of the way of life of the natives. There are, however, some sympathetic decisions. I have to say this. There are many peninsular judges who are sympathetic to the demands of the natives, to the expectations, and they recognize that life includes livelihood. And for the natives, land is part of their life. However, there is an equal number of peninsular judges who have no appreciation of how much land, native land, means to the natives of Sabah Sarawak. Next slide. Representation in Parliament. Sabah has 25 MPs, Sarawak has 31. Together, they have 56 out of 222, which means 25.2. 25.2 looks small, but actually, this is 50% of the 112 MPs needed for a working majority. We have 222 MPs. Absolute majority will be 112. Sabah Sarawak together have 56 MPs. However, it must be noted that the present 25.2% representation is lesser than the 33% envisaged for Sabah Sarawak, Singapore in 1963 in order to give these states a veto power over constitutional amendments which require 2/3 majority. So last time Sabah Sarawak could have vetoed a constitutional amendment just by teaming up. But now, with Sabah Sarawak having only 25% of the MPs, they cannot veto a constitutional amendment by themselves. Next slide. Emergency powers. Even during an emergency under Article 150, the native law or custom of Sabah and Sarawak cannot be extinguished by emergency law. Emergency gives to the federal parliament almost unlimited powers. But there are 6 topics in Article 150, Clause 6A, which Parliament or the Yang di Pertonagong cannot touch. One of them is native law or custom in Sabah Sarawak. But I'm sorry to report that emergency powers can be abused. There was abuse of emergency power in 1966 to declare emergency with the purpose of removing the then chief minister. That was the case of Stephen Kalong Ningkan versus Tun Abang Haji Openg dan Tawi Sli, which also went to the Privy Council. Stephen Kalong Ningkan and the government of the Federation of Malaysia. Sarawak lost the case because the court held that the term emergency does not only refer to war or civil disorder, can also refer to collapse of civil government. Okay, development plans. Policies of the National Land Council, National Council for Local Government are not binding on Sabah. Sabah has autonomy in this area. Next slide. Fiscal federalism. Money matters. Money represents power. Sadly, that's true. The federal government's stranglehold over most of the lucrative sources of revenue is not as strong in relation to Sabah Sarawak as it is in relation to the other states. In several areas, Sabah and Sarawak enjoy fiscal privileges that are not available to the peninsular states. What are these? Let's have a look. Next slide, please. Special sources of revenue. These states are allocated special revenues to meet their needs above and beyond what other states receive. That's Article 112C. No unilateral review is possible of this special allocation without the consent of Sabah and Sarawak. That's Article 112D. Sabah and Sarawak are entitled to earnings, that is taxes, fees and dues, on 8 sources of revenue, like import and excise duty on petroleum products, export duty on timber and other forest produce, royalty on minerals, 30% customs revenue on medicine and health products, state sales tax, state ports and harbors, state water supplies, revenue from licenses connected with water supply, Article 112C. Next slide. State sales tax. There is serious dispute between Petronas and Sarawak about Sarawak's constitutional right to impose state sales tax. Actually, it's not just Sarawak. Sabah Sarawak have the right to impose sales tax on the sale of petroleum products under Article 95B of the Federal Constitution and the State Sales Tax Ordinance 1998 of Sarawak. Fortunately, the dispute has been resolved, but outside of court, and it appears in favor of Sarawak because the details were not really divulged. Next slide. Special grants. Sabah and Sarawak enjoy special grants under Article 121C. These states are entitled to import duty and excise duty on petroleum products. Next slide. No fiscal federalism. All in all, however, there is discontent about inequitable sharing of resources and lack of fiscal federalism. There are allegations that these states do not derive the kind of financial benefit they deserve as a result of their contribution to the national coffers from petroleum, hydroelectricity, and tourism. It is alleged that federal allocations to the Borneo States do not take into account the huge direct and indirect federal earnings from these states. Next slide. Another major and extremely intricate complaint is that Sabah and Sarawak have not received the mandatory financial allocations that are due to it under the 1963 provisions. It is argued that Malaysia Agreement 1963 of 9 July and the 10th Schedule Part 4, Paragraph 2 had promised to Sabah 40% of the net revenue derived by the Federation from the state, minus amounts received by the state. It's very complicated. I can't go into details here, but it does say 40% of the net revenue minus amounts received by the state. How to calculate this amounts received by the state is a complicated question. Oil royalty, Sabah Sarawak receive only 5% of oil royalty, and obviously this is a matter of great concern. Next slide. Article 153 protection. Under Article 153, the natives of Sabah Sarawak enjoy a special position similar to that of the Malays of Peninsular Malaysia. The special position of Malays and the natives of Sabah Sarawak. But it is alleged that the protection of the special position of the natives under 153 is not vigorously enforced, in contrast with strong affirmative action for Peninsular Malays throughout the nation. I just want to point this out to you. Article 153 of the Constitution is not entirely clear on this point. Does the special protection for the natives of Sabah Sarawak apply only in Sabah and Sarawak, or does it apply throughout the Federation? Likewise, does the special protection for Malays apply only in Peninsular Malaysia, or does it apply throughout the Federation? These are issues which the Constitution did not address. So it's a matter of policy. Next slide. Borneoization of the public service is proceeding too slowly. Next slide. Immigration. To safeguard Sabah and Sarawak from being overrun by people from the peninsula, the mobility of non-residents to Sabah Sarawak is restricted. Article 161E, Clause 4, and the Immigration Act. However, it is alleged, and rightly so, that the constitutional right of the Borneo States to control immigration has been defeated by naturalization of millions of illegal immigrants into Sabah. Next slide. There is lawyers. There is restriction on non-resident lawyers practicing before the courts of Sabah and Sarawak, and in cases originating from Sabah, Sarawak. So this much is certain, that in courts in Sabah, Sarawak, West Malaysian lawyers cannot appear except with special permission. The interesting interpretation is that if the case ultimately goes on appeal to the Court of Appeal and the Federal Court, can West Malaysian lawyers appear? And the decision is that no, it must be reserved for Borneo lawyers. Then English and native languages. Sabah Sarawak enjoys special protection in relation to the use of English and native languages. The National Language Act does not apply in Sabah and Sarawak unless adopted by the states. Sabah has adopted it, but not Sarawak. So even though in Article 152 of the Federal Constitution, Bahasa Melayu is the national language, the National Language Act does not apply unless Sabah Sarawak adopt it. Thank you. Next slide. Malay Reserves do not apply in Sabah Sarawak. Appointed members in Sabah Assembly are allowed. Sabah Assembly is the only assembly, to the best of my knowledge, where not all assemblymen are elected. There are 6 appointed members. Next slide. Federal control over politics. Now I'm going slightly outside of the Constitution. Despite the autonomy of states in prescribed areas, the federal government controls political and administrative processes in Sabah and Sarawak. The federal government manipulated the political processes to remove popularly elected chief ministers in 1966 in Sarawak and in Sabah in 1994. In order to topple Stephen Kolong Ningkan, the federal government went to the extent of resorting to a declaration of emergency in 1966. That was, of course, the former Barisan national government. Next slide. The nation's age. This is an yearly controversy about whether Malaysia is 58 years old or 63 or 64 years old. East Malaysians note with displeasure, and rightly so, that Malaysia Day was not celebrated as a holiday till 2010. Even now, the celebrations are mostly confined to Sabah and Sarawak, and that's wrong indeed. Next slide. Secession. In the light of the above, a movement has sprung up asking for Sabah Sarawak to secede from the Federation. Now, I want to give you the legal perspective. Legally speaking, our Constitution contains no provision for the cessation of any state from the Federation. I know this issue has been raised in some other states also. The disintegration of the Federal Union is not provided for in the Constitution. Any attempt at separation or incitement to secede will actually amount to treason and sedition under our criminal laws. Even the 20-point agreement with Sabah explicitly stated in paragraph 7 that there's no right to secession. My understanding of the law is that if you are a confederation, then you have a right to leave, like Britain left EU, or ASEAN is a confederation. But when you are a federation under a constitution, there's no right to leave. But of course, the federation may allow a state to leave, like Singapore was allowed to leave. Next slide. Puribumi. I hope I have the spelling right. There was a political attempt some years ago to introduce the concept of Puribumi to unite all natives and to extinguish individual nationalities. Now, that was certainly an improper attempt, because both the federal constitution and the state constitutions define the native groups, and there are large number. There was an attempt to put them all under one umbrella. The attempt was abandoned due to strong opposition, and rightly so. Next slide. I'm concluding now. 58 years down the road, not all is well with the former Borneo States' relationship with the center. As has been pointed out above, in many areas, Sabah and Sarawak's autonomy has suffered retreat due to constitutional, political, social, and religious developments. So what can we do to douse the embers of controversy? I think leaders of the federal government must recognize that Sabah Sarawak's restiveness is real and must be addressed. A thorough study of constitutional, legal, financial, and political instruments need to be undertaken. The MA 63 Committee of 2018 and 2020 did make some progress. Perhaps a royal commission is necessary. Next slide. Balancing the concerns of equity and efficiency in intergovernmental financial relations is paramount. Efficiency is good, and federalization leads to efficiency. Centralization leads to efficiency. But we also need equity. We need to balance equity with efficiency. Petrol royalty issues have triggered separatist movements in many federations. Please let that not happen here. Whether it is Sudan, North and South, Biafra, Nigeria, petrol royalty issues have triggered separatist movements in many parts of the world. An amicable settlement is necessary to ensure that investors are not scared off. Next slide. I'm almost coming to the end. There is a need to strengthen institutional mechanisms for regular non-partisan dialogue between the federal government and Sabah and Sarawak, so that the inevitable tensions that are inherent in a federal setup can be resolved with the least friction. We need to recapture the spirit of accommodation, moderation, and compassion that animated the leaders of the Malaysia Agreement in 1963. The federal government and West Malaysians must rededicate themselves to the pacts of the past. Next slide. We need greater constitutional literacy to appreciate the scheme of things in 1963. I'm sorry to report that constitutional literacy is very weak. Constitutional patriotism is even weaker. Politics prevails over the law. People of the peninsula should also open their eyes to the commendable example of inter-ethnic and inter-religious harmony in the Borneo States. I think we should learn from Sabah Sarawak how to live together in peace and harmony. Sabah and Sarawak, on their part, must recognize that growth and evolution are natural and necessary in any federal setup. Federalism is a journey and not a destination, not just a set of institutions and procedures. Thank you very much.